Okay, good morning.
Good morning.
Okay, just want to let you know you should have a clock on your screen to help you keep track of your time. How much time would the appellant like to reserve for rebuttal?
I would like to reserve 5 minutes, Your Honor.
Okay, you can keep track of it, but I'll try to help you as well. Let me go ahead and mention a couple other things. First of all, the other members of the panel want to introduce you to Judge Richard Orfinger and Judge Brian Lambert. I also want to advise you that these oral arguments are being live streamed so that the public can observe them as they're taking place. Okay, Ms. McCullers, you may proceed.
All right, may it please the court? I am Christy McCullers and I represent the appellant, the mother DR in this case. This appeal appears to be, it arises out of an order determining guardianship of person for minor children. And it appears to be a unique situation wherein a mother has fundamental rights that have not been terminated, and a lower court judge used 744.312 and a best interest test, and on that basis entered an order for guardian of person in an unrelated party, which is contrary to the mother's choice of fit and able relatives and also is expressly disagreeable to the mother. The appellant is the natural mother of JAR and SHR, and her rights remain intact to this day. It's the appellant's position that the order determining guardianship and appointing the appellee must be reversed on the following grounds. The guardianship court did not have subject matter jurisdiction to determine the care and custody of the mother's minor children. The lower court neglected well-settled principles of law and ignored relevant law on the role of a parent in making these determinations. And the court erred.
About the jurisdictional, I mean, your client filed a counter petition. I mean, at the very least, doesn't that invoke the jurisdiction of the court?
So the subject matter jurisdiction of the court cannot be waived or consented to. So I would argue, no, it does not invoke the jurisdiction of the court as it relates to the mother being in charge of the fundamental care of her children. So there's a difference between extinguishing the right of a parent to control that care and custody and a mother allowing a relative to be in control and custody of her children.
Let me ask you this. I know that the trial court found that all the people seeking custody of the children were fit. But
yes,
if, for instance, the trial court had found that your clients were not fit to care for the children, would the circuit judge acting on a guardianship petition be permitted to place the children with the appellee here? And if so, doesn't that go to the argument that the circuit court did indeed have jurisdiction?
It is. So there are 3 cases that address this subject matter jurisdiction. One of them was actually brought forward by the appellee, and that's Fiel v. Pollock, wherein the court stated that as to guardianship, a trial court may award guardianship of a minor to a third party while a natural parent is living, only when a third party can show by clear and convincing evidence that the natural parent has abandoned the child. So this kind of echoes that language of the Chapter 39, where you do have a process, you do have a due process for determining if the children are abandoned. And again, the mother's fundamental rights have never even been challenged in any form. So certainly she has not been, her rights have not been terminated to determine where her children will live and in whose custody they are. And then finally, the court erred by applying this best interest test over a parent's fundamental right to determine the care and control and management of her children. So the court's order expressly says that it believes it's in the children's best interest to continue in the care and custody of Heydrich. However, in MMA versus Johnley, the 5th DCA determined that the lower court has no jurisdiction to conduct even a proceeding that would appoint a guardian ad litem over a child, much less an actual guardian over a child. And the court said, unless that was brought pursuant to a Chapter 39, a Chapter 61, or a Chapter 63, that parent should have no special interference in their decision-making. And if an adult could do this, then any adult could do this as to any child in the state of Florida. And also in re-guardianship of JLC, the second DCA stated, as a father was petitioning to end a guardianship that he had consented to, the court said that the parental rights cannot be determined in a guardianship proceeding. So some of the well-settled fundamental principles of law are that the fundamental rights of a parent to care, control, and for the management of their children also allows that right to delegate the authority to whom the children will be placed. So, for example, choosing a private school over a public school, or choosing guardians that you would like to have in a person's life, or allowing visitation as far as grandparents versus parents visitation, I think is probably the most extensive case law that we have as it relates to even a grandparent visiting when a parent chooses not to have that grandparent as part of their life. There is the standard of a compelling interest test when we're talking about fundamental rights instead of the best interest test that the court applied here. There is no compelling interest in anyone preventing the fit and able aunts to be the guardian, and unless and until the mother's parental rights are terminated, it should not be a best interest test that's applied. So there are two appropriate places to apply a best interest test.
You don't see this case any different than a scenario where dad dies, natural causes, mother is going to be going away for 6 months, either on deployment or going to jail for some unrelated matter, and the teenage kids are living at home with mom. Mom says, I want the teenage kids to go live up in Jacksonville. The teenage kids don't want to leave the area, and so they go to the next door neighbor and say, hey, can we live with you because we want to go to school here with our friends? And that neighbor can't come in and petition the circuit court and say, hey, I know mom wants the kids to live with grandma 2 hours away, but we want to live with our neighbor. Our neighbor says it's okay. And assuming the neighbor's fine, you're saying that the judge in that scenario has no authority to say, okay, mom, I know you want the kids to live with grandma, but guess what? It's better for the kids to live with the neighbor here. So go to the same school. So I'm going to do that.
Not substantially, no, Your Honor. I don't see that as being different than this. I mean, we do have the level.
The underlying theme in this case seems to be, at least my take on it is, well, you're the lady that's purportedly killed the father. So guess what? You don't get to have much of a say anymore in this. And we're going to see what's better for the kids away from the house where dad died.
I think the key word there was purportedly. Like, we have an alleged crime. Mother has not been convicted of anything. She hasn't pled guilty to anything. She has certainly not been alleged to have done anything to the children directly.
But there was a probable cause finding by a judge, which resulted in her being held in custody. So although she hasn't been found guilty, the judge has made a probable cause finding.
However, even being arrested and even being convicted for a crime doesn't terminate automatically a parent's rights. So we do have a process for that under the abandonment in Chapter 39. But here, there was no process. There was no due process for the mother to even argue. She was served 2 days before she was brought into an what turned into an emergency temporary guardianship hearing. She was unrepresented. If the Chapter 39 proceeding had gone forward, then she would have at least had the opportunity for counsel and to take a step back from everything swirling around her. The court, it's the mother's position that the court impermissibly entered into an analysis of the actions, and apparently she has prejudged the criminal case. The allegation all along is, if this had been a Chapter 39 hearing and the mother's rights had been terminated, or in any way called into question, that no, she should not be able to name that. But until that's done, we need to allow the mother to make a decision that is in the best interest of her children, because she's the mother. She knows them. She knows where they should be. She knows their connections to the family. And at the time that this was done, it wasn't like a next door neighbor was being asked to take care of children for 6 months. The appellee had only met the 11-year-old at that time on 2 occasions. He did not know this person at all. And being swept into this without the mother's consent, permission, even having a meeting with the mother about what you were planning to do, I believe is, it's a very different situation than a mother being deployed or something like that.
What about
Up in
finding of clear harm to the children?
there,
Not necessarily, no, I understand that there was no
okay,
finding like that here. I'm just
Right.
saying, would the court, for example, if Miss Heydrich had petitioned the court and said, dad's unavailable, mom is unavailable at the moment, regardless of the reason
mhm,
why. And there's clear harm to the children because the proposed custodians are, meth addicts. And I'm just making that up. I'm trying to make up an example where there's clear harm to the children. So
And-
the court be free in that case to say, I'm not making a best interest analysis, but I'm finding that there is clear harm to the children to go with the meth addicts.
And I believe that that would be the appropriate use of the doctrine for stepping in where the child is not cared for. But again, that is a Chapter 39 proceeding. And actually in one of the hearings, it comes out that DCF was called when the aunt and the grandfather were in the house caring for the children. DCF came out and they found the children did not require shelter, that they were being cared for by competent adults, one of whom is a social worker in Ohio, and the other one is a grandparent.
The guardianship statute does anticipate sometimes minor children being the ward, correct? And then they reference that, at a certain age, the child's preference should be considered. So
Yes.
at least anticipate that minor children might be involved as potential wards.
However, as the 3 cases that are referenced, when it's comparing a guardianship of a minor child who has a fit and able parent whose rights have not been terminated, even though they're unavailable temporarily, the standard is not appropriate to apply a best interest standard. And
Right, now I'm just trying to get to the first issue of whether the court had jurisdiction, or as distinguishing that from the second argument that the court applied the wrong test by using the best interest test.
Again, the case law, there is very little case law on this topic, because I think normally our wards are the older people, and once they're adjudicated and capacitated, yes, the court is very free to apply a best interest test for an adult. However, it's not the same standard when you have a fundamental parental right
But I think
triggered.
Judge Evander's question was, it's clear that the Chapter 744 contemplates that you could have minor children as guardians. I mean, for example, it says you don't have to have an incapacity here when you have a minor child. So,
Sure.
I guess what I'm trying to do is distinguish between your jurisdictional argument and your argument that the court had jurisdiction but applied the wrong test. I'm not really seeing my way clear on the jurisdiction, because it seems to me now the jurisdiction may have been improperly invoked in this case. I mean, maybe this was a case where there was no reason to invoke it, or maybe this was a case where the court applied the wrong test. but it seems like the court has the jurisdiction when you look at the statute, and it does talk about incapacity being unnecessary for minor children.
So the difference here is in how you define the ward, and because the statute is very broad and sweeping when it's applied to those minor wards who have parents, I think that's where the statute itself doesn't distinguish and improperly doesn't distinguish, because it doesn't protect the fundamental rights of the parent who is still living.
If we agree with you, are you asking that the case be reversed and that your clients or your client's designee, the aunts, be appointed guardian? Or are you saying that we should just have the case dismissed entirely?
Well, the result in this case would not be any different. The result would be the mother would ask that the aunts be the guardian. Whether that would be in Florida, I don't know. And it may be possible that the mother could simply do a healthcare surrogate of minors and allow, Orange County Public Schools just has a form for an incarcerated parent to fill out for someone else to act educationally.
Yeah, but
so
if the kids need medical care, if the kid needs braces, that's not going to help you with those sorts of issues.
Actually, so the healthcare surrogate for minors is very broad and would allow for that care if the aunts needed to procure care for either one of the children in an emergency situation. That healthcare surrogate would do that.
Okay, you're at 4 minutes. Do you wish to reserve the remainder of your time for rebuttal?
Yes, Your Honor.
All right, thank you. All right, Ms. Pepe, am I pronouncing that right?
You are, Your Honor. Thank you.
Okay.
May it please the court, Renee Vermette Pepe. I am counsel for Elizabeth Ashley Heydrich, who is the court-appointed guardian of the person of both minor children in this case. Ms. McCullers mentioned from the outset that this was a unique situation, and I would wholeheartedly agree with that assessment. And I think that this court's decision is dictated in large part by your assessment of the unique factors in this case.
Well, let me ask you about that. This is a follow-up to Judge Lambert's question. If, for instance, you had a single mom, father was deceased, and she was going to be deployed, for a year overseas, and the children couldn't come with her, would a neighbor be able to file guardianship to keep the children if the mother said, no, I want them to go with my mother, the grandmother living in Jacksonville?
I think there are a few assumptions in play in that question, Your Honor. I believe that the reason that this matters before the court is because while the mother placed the children in the physical custody of third parties, there was no decisional authority given, no legal authority to make the decisions that I believe Judge Orfinger brought up in his inquiry.
Right, but let's assume that the mother has made the decision that she wants the children, in the example Judge Lambert gave, to go live with her mother, and there's no question about her fitness, and the children want to live with the neighbor files a petition. Would the judge have the authority in that scenario to say the petition's granted, the children are to live with the neighbor because I find that's in the best interest of the child?
I think that the court would have jurisdiction to, in the event that there were to be an allegation, as in this case, that there was not the authority that was necessary to attend to the needs of the children, which is what happened here. There were two.
Again, the hypothetical I'm asking assumes that the neighbor's a fit parent, the grandmother's a fit parent, the mother's going to be overseas, deployed militarily, and you have this petition. Would you apply the best interest test, or would the mother's wishes be entitled to be enforced by the trial court?
I think that the mother is natural guardian. I would stipulate to a few things to clear the air on a few levels. I think that we stipulate that the mother is natural guardian. As such, she's parent and she has a fundamental right to privacy. And I would stipulate that you cannot determine parental rights within a guardianship. But I would likewise say that this is not what happened in this case. was not a
But
determination.
in the example I gave you, would it be
Correct.
error
I'm
for the
sorry,
trial court? Would it be error for the trial court to grant the petition of the neighbor and not allow the children to go to Jacksonville with the person selected by the mother when she's been employed overseas for a year?
If the mother, it would be error if the mother had not ceded her parental authority, had not
Well,
provided.
I guess I'm missing this and you don't seem to want to answer either mine or.
And I apologize, I'm not intending, Your Honor.
Well, I guess how does your client have the dog in the hunt here? I mean, if the mother says, I want the kids to go live with my mother, the grandmother in Jacksonville because dad's dead and I'm going to Afghanistan, I've been deployed, and that's what I want for my two kids. They know grandma and I want them to go there. And why does the neighbor get to jump in and say, well, I don't think I'm going to jump into this family dispute and I'm going to file a petition with the circuit court because I want to keep these kids because they want to live with us. Where does your client, or where does the hypothetical petitioner in Judge Evander, in my case, get that authority to jump into the fray?
So standings conferred on interested parties, persons interested in the welfare of the children by statute. If that's your question, I'm not intending to avoid answering your question.
Then I guess following that is then anybody can jump in because they're quote unquote interested because they're walking around and they're concerned about kids, and they can jump in and say, well, I don't know that I've seen a sufficient documentation that the mother who's being deployed has taken the proper steps to allow grandma to be able to enroll the kids in school, take them to the doctor, et cetera. So I'm going to file a suit. And mother comes in and says, I want the kids to go with grandma, Judge. Can't we just comply with my wishes? I'm fine, grandma's fine. And the judge gets involved in the best interest and says, well, I think the neighbors who, for whatever reason have a lot more money or whatever are better. So the kids are better off there. I'm stunned if that's what you think the law is.
I think that the legislature has spoken to this issue. If you review 751, the legislature is very clear in that individuals with physical custody of a child do not have the authority to make the decisions that are necessary to be custodians in the legislature's language.
Well, let's make the hypothetical a little closer to this case. The neighbor has filed a petition and the grandmother has filed a counter petition. They're both before the court. The court's holding a hearing. The mother testifies, I want the children to be with grandma. So now, we have both parties saying that they have, we've gotten over the procedural hurdles you've mentioned, I would assume. Would it be error in that situation for the trial court to apply a best interest test?
No, it would not. They have submitted to the jurisdiction of the court, the guardianship statute 744-312 speaks specifically to the guidelines for the court in making that assessment. And then it would be two third parties, as in this case, does not involve the right of the parent to have physical custody of the child. It would be third party versus third party. The mother's right to be heard is addressed by the legislature as next of kin in this matter. As
Okay,
this court
so the uniqueness of the facts in this case, with the mother being charged with the murder of her husband, would, accepting your argument, would not be particularly relevant, because you're saying as soon as both parents are not in the picture as a practical matter, then you go strictly to best interest test.
I'm not suggesting that the mother's wishes be ignored. I don't believe that the court ignored her wishes. I think the hearing on February 20th.
But you're still saying the best interest test applies.
Correct.
Regardless of whether the mother's charged with second-degree murder. It would apply even if she was just going to be deployed overseas for a year or was going to be in jail for 6 months on a misdemeanor or whatever. Your position is still, as long as you got the petition, the counter petition, the best interest test applies.
I would, Your Honor.
Okay.
Ms. Pepe, let me
Yes.
ask this, and I'm looking at a case from our Supreme Court called Beagle versus Beagle. And they start off in that case, the Supreme Court talked about how parents have a fundamental liberty interest in determining the care and upbringing of their children free from what they referred to as the heavy hand of governmental paternalism. But they go on to quote the Georgia Supreme Court, and this was a grandparent visitation dispute, and they say basically you can only override the wishes of the parents if there's demonstrated harm to the children. It's irrelevant to the constitutional analysis that some other action might be better or desirable, unless the government or the petitioner can demonstrate actual harm to the child. The parents' wishes control. And the Supreme Court goes on to say, we agree with this reasoning. To me, that suggests that the Supreme Court, in a contest between a parent whose parental rights are intact and some other third party, that unless the parents' desire would work demonstrable harm on the children, the parents' rights, their constitutional rights, control. Why would that not be the case?
I do believe that there are competing interests. I think that the US and Florida Supreme Courts have both recognized repeatedly that the state has an interest in this matter, in matters such as this, and that the children are deeply interested in these matters as well. But I do believe that jumping to the constitutional analysis is premature, in that the mother, by virtue, I had started to say, if you review the transcript for the February 20th hearing, the court engaged in a very lengthy dialogue with the mother, at the end of which the mother consented. When you review the totality of the circumstances, the mother consented to the appointment of an emergency temporary guardian. That puts this case squarely within the jurisdiction of the court under 744 to make the assessment that it did, with the best interest in analysis to be applied. I'm not suggesting on any level that the mother's fundamental rights have been infringed upon, intruded upon, as the courts, the language that they use.
Aren't her fundamental rights intruded upon if, in the absence of demonstrable harm to the children, the mother's wishes are overridden?
The court did find, I believe it was implicit in her order, that there was demonstrable harm under the circumstances. Now, did she apply where we were looking at the Richardson, the fitness of the parent versus the demonstrated harm to the child? I don't believe that standard was applied necessarily, because the judge was working within the parameters of 744, which was properly before the court. So the mother submitted a consent and waiver in support of her position, an unnotarized document saying that she consented to person A being appointed. Yet this case has to start from the inception, is at that first hearing, when, after the judge repeatedly discussed with her, she came back, I believe it was 7 or 8 times, and said, you are the natural mother. You have a say in this. She actively engaged the mother in the dialogue. And after a conversation with all parties, but again, active engagement, the mother made intelligent inquiries into what rights she may or may not have been giving up, what the circumstances were. And at the end of that dialogue, it was determined that it was in the best interest of the children, until the mother followed through with something. We had 2 third parties approach the court.
That horse is out of the barn. That all related to the temporary guardian. And so, we can't undo that. And I don't even think it's relevant at this point. We're really focused upon the appointment of the permanent guardian. And so we have 2 parties who are apparently fit. We got the Ohio folks and the Florida folks. Everybody's apparently got good hearts and well capable of taking care of the kids. Mom clearly wants the Ohio folks. Kids clearly want, or at least the older child clearly wants to stay in Florida. But when I read the order, I see the court do a typical best interest analysis and reach a conclusion, which, if that's the test, is probably supported by competent evidence. If that's not the test, if the test is there's got to be demonstrable harm, meaningful harm to the children to override the mother's wishes, then it doesn't appear to me that the court applied that test. And I'm just trying to understand how you get around why you argue that this is a typical best interest analysis versus the demonstrable harm that the Supreme Court's talked about in Beagle and other cases.
Because the legislature has told us that, Your Honor. The legislature has said, contemplating that a guardianship of the minor was appropriate in some circumstances, presumably cases like this, that the mother's consent would be considered. The mother's input as next of kin is contemplated. They don't disregard the mother, but they likewise make it a best interest analysis in terms of considering what the children's wishes are, which has been recognized by the Supreme Court, and considering the demonstrable harm within the parameters of the best interest.
Wouldn't the statute be unconstitutional, though, if we didn't apply the demonstrable harm standard as opposed to the best interest standard in an instance like this where we're looking to override the natural guardian's wishes?
I think that the legislature has contemplated very specifically what parental consent should consist of under any number of circumstances. I think the fact that there's a guardianship being petitioned for here, not custody of a child, not termination of parental rights, the less restrictive of those alternatives, that the guardianship by its very nature was less restrictive, and that the mother's rights were contemplated within the parameters of what the legislature has determined is the best, is the test.
In the Beagle case, the legislature contemplated that grandparents would have visitation rights. And the Florida Supreme Court said, no, legislature, we're not going to find that statute to be valid in those cases where, there wasn't a finding of demonstrative harm to the children. So why wouldn't that constitutional holding, if you would, in Beagle, if it applied to a statute granting grandparents legislative rights, why wouldn't it apply similarly to a guardianship statute?
I think it's easy I found myself getting pulled off in terms of all of the other subject matters where this issue was considered. I think that this case in the guardianship realm itself is unique and can be distinguished from grandparental visitation, MMA versus John Lee, as cited by counsel, in that we have a parent here who cannot exercise physical custody and has not exercised her right to decisional autonomy. She had failed in that respect. And I know that goes back to your original.
Even in dependency cases, TPR cases where, say, you have a parent who's incarcerated for a lengthy period of time, and that would meet the legislative grounds under Chapter 39 to terminate parental rights. The Supreme Court has still said, to make the statute constitutional, you still have to find it's the least restrictive means. And it's in the children's manifest best interest to terminate parental rights. So even in that scenario, the Supreme Court has engrafted constitutional requirements upon a statute.
Understood. And I think that
and even in cases where the parent is unavailable to care for the children.
Correct. And they all provide for parental consent, as does this particular statute. Consent in the guise of the wishes of next of kin, tempered by all of the other considerations that the legislature has said are appropriate under these circumstances.
So if I'm following this, all right, dad's dead, let's say mom's not going away. She's got the 15 and 11-year-old children at home, but mom is ill. And it's not contagious, so the kids are not endangered, et cetera. Mom's ill, and she says, you know what, for whatever physical limitations I now have, I can't take care of these kids as well as I used to, but I still am sharp in the mind. I want my mother up in Jacksonville to take care of them, so I'm going to have the kids go live with them, and we'll see how I do with my illness. Your neighbor can come in and say, well, you know what, I think the kids are better off with me because I can take them to the swim meets or whatever the older daughter did, and they like, they're best pals, and that neighbor can jump into the fray.
Well, I think
to appoint guardian of the person, even though the mother's alive, the mother's there, she's just ill and made a choice that the kids live with grandma.
I think
yes.
Well, I just did not want to interrupt, Your Honor. I
Go ahead.
think that again, the facts of this case dictate how we answer that question. I think there's a presumption that here that the kids can just float out there with no authority for this person to, contrary to the legislature's intent in enacting 751. Two third parties came to this court under a different guise. Her family members came under a 751, alleging that they needed authority to care for the child.
Apparently, in light of the fact that somebody else was trying to exercise the authority, they came in, right?
Well, we're assuming that. I don't know the facts of that, Your Honor. I know it was filed.
Isn't that chronological?
It's possible, it is. But then that begs the question that the individuals in question likewise felt that authority needed to be conferred. And I do, this court has, and it's a very old case, but the Supreme Court in Reeves said that there are situations in which if the parent is unable to parent effectively, that the court has jurisdiction. But we are going back to the original question, dismiss it as it may well be that she consented to the appointment of a temporary guardian in the interim to allow her to pursue other mechanisms to, as we've discussed, there were three options. She could have petitioned for guardianship, she could have petitioned 751, or she could have simply executed the documents in question. Yet months went by, nothing happened in that respect, and she fully engaged the guardianship court, submitted to jurisdiction, and argued that 744 should be applied. So it's only now, and the court did consider her wishes and did readily acknowledge her as natural parent and listened to her wishes. But it's applying the legislatively driven best interest test, felt that other circumstances outweighed and that the mother's decision should not control.
All right, thank you, Ms. Pepe. Ms. McCullers, you have a little under 4 minutes left for rebuttal. May proceed.
Thank you, Your Honor. First of all, to address the situation where the unrepresented mother is brought before the court and questioned repeatedly about appointing an unrelated party to be the emergency temporary guardian, the mother continues to say, we were doing this, we were working on this. There is a 751 petition already in place, which in the February 20th hearing, the lower court judge sort of dismissed it out of hand and would not allow that to be heard as a competing idea or concept. Secondly, this is no normal next of kin. All the cases cited in the lower court's order, the lower court alleges that it's using the best interest of the child as trumping the preference given to a ward or to somebody or to the next of kin. But this is not a normal next of kin. This is a parent, and only that parent has the fundamental right, which requires more than a best interest analysis when she is stating and saying over and over again, this is who I want. And Ms. Pepe aptly references that the mother was not taking control of the situation and making that decisional authority. That is simply not true. The mother had placed the authority. There were documents in the hands of the aunt and the grandfather allowing communication with the school. And also she was willing to do a healthcare surrogate. She was not represented by counsel, and there was nobody until the July hearing about a week before that to walk in and say, well, why don't we do this? And the mother has executed power of attorney for me, for example, to go to retrieve report cards. So what is fundamentally missing here is the court order itself says that the court deems it in the child's best interest to remain in the care and custody of Heydrich. The court says that the Florida law is clear that the best interest of the child trumps the preference given to anyone else. However, the cases cited are all cases involving adults who are either elderly or incapacitated. I believe one of the adults is 85 or 95 or something like that. And yes, the next of kin can be not appointed in those circumstances, but this is not a normal situation. We have a parent with her rights intact who should be allowed to exercise that authority under the least restrictive means, which would include a variety of execution of documents or even asking the court to name them as the temporary custodial parent in a relative. However, if the court rules that that the statute is being followed under 744-312, I would have to argue that is not subsumed under the Constitution. Every statute has to be addressed within a constitutional framework that will allow it to be construed within that framework, and that using the best interest test when you have a parent who's alive objecting to it would be inappropriate, and that would be an unconstitutional application of the
Right.
statute.
Thank
Thank
you,
you.
Ms. McCullers. Thank you both. That concludes the oral argument session for this morning. You all have a
Thank
good
you.
day.
Have a great day. Thank you.